LME3701, Section B. Okay, so I'm just going to discuss from Learning Unit 6 until I think Learning Unit 12, all in one go, and then Section C as well. But Section D, which is just the miscellaneous things, I'm not going to discuss today or at all because you can just study that in your own time. Okay, but let's start with Learning Unit 6. Points of departure and assumptions. 6.1. Points of departure and assumptions. The point of departure refers to two things. In the first place, it refers to the basic theory behind a research project. It is important to consciously formulate one's point of departure because it provides a test of consistency throughout the module of the research and gives direction to the making of basic scientific, especially theoretical, choices. If, for example, you study the position of women after divorce, you could do so purely from a patrimonial point of departure, that is, from the private law theoretical perspective, or from a procedural point of departure, that is, from the point of view of the law of civil procedure, or from a feminist viewpoint, that is, the study of feminist critique of divorce law. You can see that in all these cases, the content and conclusions of the project will differ widely, even if they deal with the same subject. Therefore, the same subject from different points of departure will lead to different research projects. Your point of departure is basically the angle that you are taking to look at the research problem. It is from a constitutional law perspective or administrative law perspective, etc. In the second place, the point of departure refers to the method of research that you choose. You may use a historical method, a comparative method, for instance. These methods were discussed in previous sections, but you must state the method you choose explicitly in this section of the research proposal. Almost inevitably, though, legal research will largely be based on a literature study. The nature of this material, that is, legislation, decided cases, journal material, monographs and textbooks, electronic resources, material of other disciplines, sources in other languages, etc., that is expected to be of greatest significance for the research may also be indicated here. The proposed method must be must be suitable for the resolution of the problem statement. In order to limit your study and keep it manageable, it is frequently necessary to make certain assumptions. Usually, the making of an assumption entails that a certain state of affairs is taken as a given. For example, it is not necessary to prove that South Africa is a constitutional democracy. You can take it as proven. Assumptions are there so that you do not need to prove everything, so that you can exclude some things from your study and to make use of well-known previous research. In other words, this is where you say what you will be doing, but more importantly, what you will not be doing. This is important to forestall any possible criticism about things your examiners might think should be in your dissertation. If you say you will not be doing certain things, they cannot criticize you if you do not do them. Okay, so here the learning units get very short or a bit shorter, but this is just so that you can review when your paper is already finished or anything of that nature. Okay, learning unit 7, conceptualization of central research themes. Your research topic will relate to certain terms and or themes. You are required to provide brief definitions of your central research terms and or themes, here with reference to authority. For example, if your research topic is the defense of child offenders in the pre-trial and trial phase of the South African criminal process, you may consider defining precisely what you mean by defense counsel, also child offender, pre-trial and trial. Defining your research terms and/or themes allows the reader to operate within your frame of reference with certainty as to your meaning and interpretation. Although the example used is very basic, this task becomes important when your research relates to terms or themes that have no definite meaning, such as dignity, Ubuntu, values, and the like. Because researchers differ in their views on certain terms or themes, it is very important to inform the reader which definition you accept to be correct within your research framework. These central research themes come primarily from your literature review. Learning Unit 8, Chapter Layout. Your proposed chapters must cover all the aspects of your research adequately. Your breakdown could, for example, reflect the following. Table 5, Chapter Layout, Example 1. Chapter 1. General conceptualization of research problem and methodology. This chapter will conceptualize aspects of the research problem necessary for the development of the dissertation in later chapters. Chapter 2. General contextualization of the research topic in South African law. Chapter 3. Comparative analysis of topic in chosen jurisdictions, only if you have chosen a comparative method of research, or historical review of the development of the topic in South African law between 1910 and 1994, if you have chosen a historical method of research. And Chapter 4, Conclusions and Recommendations. Depending on your method of research, you may have more chapters than those described above, and you must indicate the content of each chapter. The framework for your research proposal depends largely on the topic and your chosen research method. We, however, suggest that when you start the process of writing, you use the following temporary framework. This framework is based on the use of comparative research. If you use a historical method, you will adapt this format accordingly. Then there's Table 6, Chapter Layout, Example 2. Chapter title and then the content. Okay. Research parameters and conceptualization. This chapter is, in essence, your research proposal and an explanation of the concepts you intend to use in the research. If your dissertation is a map, then this chapter is the legend to the map and provides the reader with the GPS coordinates to your eventual destination. That is your conclusions and recommendations. Contextualization of theme. This chapter contextualizes your theme in the South African framework and often includes aspects relevant to international treaties, the Constitution and the history of the legal aspects you are researching. The South African perspective. This chapter tells the reader about the legal position in South Africa regarding your chosen topic. It provides the law and your analysis of the law. Comparative perspective. This chapter presents the law concerning your research topic in a comparative jurisdiction and must show the similarities and differences between the two countries. And then the second comparative perspective. Depending on whether you are doing an LLB research report, an LLM, or an LLD, you will have more than one comparative jurisdiction to compare. Your chapters must show the differences between South Africa and the comparative jurisdictions. And lastly, conclusions and recommendations. This chapter provides your conclusions, your summary of research, which must answer your hypothesis or addresses your research aim, and include your recommendations, which are supported by the arguments you presented throughout the research. And that's the end of Table 6. Obviously, the above is not suitable for every topic and is definitely not developed enough to be a complete product. It does, however, give you an initial structure to work within. Your product may have more or fewer chapters or may choose to examine themes as opposed to jurisdictions, which would then be presented as follows. And then chapter 7, chapter layout example 3, the chapter title and then the content. Research parameters and conceptualization. This chapter, in essence, your research proposal and an explanation of the concepts you intend to use in the research. If your thesis is a map, then this chapter is the legend of the map, the legend to the map, and provides the reader with the GPS coordinates to your eventual destination. Contextualization of theme. This chapter contextualizes your theme in the South African framework and often includes aspects relevant to the international treaties, the Constitution, and the history of the legal aspects you are researching. Theme 1. This chapter tells the reader about the legal position in South Africa and your comparative jurisdictions on a specific theme. For example, this chapter could deal with the procedure for arrest. The author then tells the reader the law regarding arrest in South Africa, Germany, and Japan, or whatever jurisdictions were chosen to compare. Okay, theme 2. Same as the previous chapter, but with a different theme. For example, if your topic is arrest procedure, your next theme may be the use of force, in which case you will give the reader the legal position on the use of force in South Africa and your chosen comparative territories. Lastly, conclusions and recommendations. This chapter provides your conclusions, that is, your summary of research, which must answer your hypothesis and recommendations. These are supported by the arguments you presented throughout the research. Then that's the end of Table 7. Obviously, the higher the level of degree, the more themes and therefore chapters you will have. Again, the above is not definitive and may be altered to suit your topic. Both the suggested frameworks are intended to merely order your thought process when you write your research proposal and demonstrate to the reader that you have a plan for your research direction. Learning Unit 9. Your time scale tells us when you expect to submit work and what work you intend to submit for comment. The following is an example of a time scale. Okay, then you can just study Table 8 on your own time. And then they just note, obviously, the details above will change depending on the degree you have registered for, but the format and concept remain the same. For purposes in LME3701, your projected timescale will relate to the submissions of the final research proposal and not to chapters of a thesis. Learning Unit 10. Description of research method. In this part of the proposal, you will explain your research method and design. If you choose a comparative method, you are required to explain which countries you are using to compare and why you have chosen those countries. If you have chosen a historical method, you must indicate the time period you will be researching and explain why that particular period in history is important. In the case of a pure historical study, you will concentrate on one jurisdiction. If you combine the historical and comparative method, in other words, if you explain the historical development of a particular aspect of the law in more than one country, you must indicate the time period, the countries, and the reason for your choice of the time frame and jurisdiction. The function of this stage is to indicate the means by which the research objectives will be achieved and to indicate the sources of data to be used. Here you need to explain how you will obtain the information necessary to write your research paper. You are required to, first, explain what sources you intend to use, and secondly, give some details on exactly how you will obtain your information. As a law student, you will probably rely on documentary sources, that is, information that already exists in some form. For example, journal articles, case reports, legislation, treaties, or historical records. You may need to say a little about how you will access these sources, keeping in mind that as a student at Unisa, you have access to massive legal databases. Your research method will more than likely be desktop. If that is, if you will use written sources to construct your argument. Here you will use a qualitative approach to research. Your sub-method can be primarily historical. That is, show how particular legal concepts developed, or comparative, to show how South African law compares to other jurisdictions. Learning Unit 11, Preliminary Research. The function of this stage is to list all references you intend to use or have already consulted in the research proposal. You may use the bibliography format provided in Section C of the study guide, followed by a brief description of each source. At LLB level, you are expected to provide at least 10 sources consulted in preliminary research on the topic provided to you in Tutorial Letter 101. Learning Unit 12. Evaluating your research proposal. The following indicators used in the School of Law when examining whether a research proposal meets the required standard. Okay, and then there's table number 9. Number 1, your title. And then there's a checklist. Number 2, contents. The checklist continues. Number 3, research methodology. Number 4, ethics, where applicable. Number 5, CLAW citation methods. You may also refer to the following rubric to determine if your research proposal is ready for submission and consideration before you submit to your supervisor. And then there's table 10, a nice checklist, which you will have to apply to your own paper. So unfortunately, I cannot cover that. And then section C. I'll just cover here what I actually can cover. Okay, number 1.1. See law referencing style. The most important way to ensure that your work passes the test of academic integrity is to indicate where you found the information. This shows that what you are saying is not your own ideas, but you found them or read them somewhere else. Conversely, anything without a reference is regarded as being a claim that is your own idea. Therefore, if you make a statement that is not your own idea but without giving a reference, you are committing plagiarism. That is why it is so important to get this right. It is the most technically challenging part of your studies, and it is important that you adhere to the rules set out below. 1.2. Basic rules of referencing in the School of Law. A. The method of referencing is set out below is applicable to all documents produced for research work in the School of Law. Deviation from this is only allowed in exceptional circumstances, and then the deviation must be consistent throughout the document. B. The School of Law does not use the Harvard method of referencing where the source is given in the text, such as Karels and Pinar 2015-57. This is because references are usually long and would interrupt the argument. C. The School of Law does not use the method of referring to abid, id, supra, infra, and so forth. Nor does it use the method of referring by using square brackets to note above, as this makes it almost impossible to keep track of footnotes. Okay, D. All references must be in footnotes and not in endnotes. E. A footnote is always followed by a full stop. Nice to know. F. When citing your sources in footnotes, provide the full reference to the source in the first time you refer to that source, and then use the shortened version in the rest of the work. G. Your work must be supplied with a bibliography in which you give the complete reference to the sources you cited. H. The footnote number is always in superscript and follows the full stop or other punctuation mark and not the other way around. 1.3 Specific rules for different types of sources. 1.3.1 Books and contributions in books. Your bibliography should have long and short references. The first time you refer to a source in a footnote, use the long reference. Thereafter, use the short reference. Always indicate the page number where you found a piece of information in your footnotes. The basic form of reference to a book is, for example, the author, that is Smith C., The Law of Insolvency, 3rd edition, bracket, Butterworth, Durban, 1988, close brackets, number 3. Your bibliography should have long and short references. First time, refer to source in footnote. Use long reference. Thereafter, short reference. Always indicate page number where you found a piece of info, only in FN. The shortened form would then be the author, but just Smith, no initial, insolvency, and then the number 3. Note the following. A. There are no commas, full stops, colons, or semicolons anywhere. B. The surname is given first and then the initials. This is followed by the title of the book in italics and then the edition and then the publisher, the place of publication, and the date of publication. The last number is the page of the book you consulted. C. As a general rule, always use the latest edition of a book unless there is a good reason to refer to an older edition. D. There are different forms used if there is one author or more than one. See the examples below, which you can study on your own time. Okay, and E. Normal capitalization is used in the titles of books and contributions in books. Okay, and then it's just the examples. 1.3.2 Journal articles. The basic form of reference to a journal article is, for example, Stander AL, die eienaar van die bates van die insolvente boedel, 1996 THRHR 388 to 399. The shortened version is Stander 1996 THRHR 385. Note the following. A. The title of the article is not italicized. It is in lowercase, except where capital letters must be used, and is followed by the date of the journal. B. The titles of journals are, wherever possible, abbreviated with an explanatory list of abbreviations supplied. The abbreviation is italicized. That is the THRHR, I presume. C. Newspaper reports are cited similarly to contributions in law journals, except that the exact date of the newspaper is given. For example, Nkwiaza B. Socioeconomic rights must be enforced in South Africa. Bidjana, 1997-09-19. Business Day 4. The shortened form is Nkwiaza, 1997, 19th of September. Business Day 4. Okay, moving on. Number 1.3.3. Old authorities. There are very specific ways of referring to Old Roman and Roman Dutch sources. If you are doing this type of specialized research, please consult your supervisor on the correct method. Number 1.3.4. Internet sources. The basic form of references to an internet source is Mamupa B, the Act on Higher Education, and then the web address. Date of use, the 16th of November 1997. The short version is Mamupa, the web address, date of use, the 16th of November 1997. Okay, note the following. A. If the author is not clear or there is no author, such as with institutional websites, the full reference is merely the web address and the date of use. For example, there's a web address and then in brackets the date of use, the 17th of September 2015. This will also be the short version. Okay, B. Legal academic journals that are published on the internet, such as the Potchefstroom Electronic Law Journal, are cited in the same manner as normal journal articles and not as an internet source. 1.3.5 Law Reports. The full version of a reference to a court case is as follows. Hofmann versus South African Airways 2001 1 SA 201 in brackets CC and then in squared brackets 23. There is no shortened version for case law, but see the notes below. Note the following. A. If the work makes repeated reference to a case, a shortened form can be used. However, it must be clearly stated that this is the abbreviated form that will be used. For example, Hofmann versus South African Airways 2001 1 SA 1 in brackets CC here and then in the same brackets here and after the Hofmann case. Okay, and B. Specific sections of a case are referred to with reference to either the pages, for example, 263H, where it is indicated in the reported volume, or a paragraph of the judgment, as has become customary in judgments. The paragraph is identified by way of square brackets, for example, in square brackets 137. Case C. In all cases, the reference to the court will be the one used in the specific law report. And D. Foreign case law and regional or international case law must be referenced in the manner in which the specific law report states. Number 1.3.6. Legislation. The basic form of reference is Patents Act 57 of 1978. There is no shortened form for legislation, but see the notes below. The correct form of reference to the Constitution, for example, is the Constitution of the Republic of South Africa, 1996. Note the following. If the work makes repeated reference to an act, a shortened form can be used. However, it must be clearly stated that this is how it will be used. For example, Patents Act 57 of 1978, hereinafter referred to as the Patents Act in brackets. B. If the work only deals with one act in some detail, the reference will be Patents Act 57 of 1978, hereinafter referred to as the Act. And then C. This is particularly true if the Constitution will be dealt with in any depth. For example, Constitution of the Republic of South Africa, 1996, hereinafter referred to as the Constitution. 1.3.7 International and regional instruments or documents. Note the following. The most important international and regional documents may be found on the official websites of international and regional organizations. The Pulp Guide also provides internet websites where international treaties and documents can be accessed. The United Nations Document Research Guide on the official website of the United Nations, with a web page right there, gives an overview of the different types of documents and publications used by the United Nations and provides guidance to researchers on how to work with these documents. C. International Legal Materials, the ILM, is a bi-monthly publication of the American Society of International Law. Each issue contains inter alia the full texts of treaties, judicial and arbitral decisions, and documents of international and regional organizations. D. There are also some other useful works that contain the texts of international and/or regional documents. And then there's just a few examples. And then 1.4, a summary. It's just a summary for everything that we discussed now and how to reference them, which is actually very nice. And then there's section D, the miscellaneous things. Well, I hope you guys enjoyed working through this with me. But luckily, that's over now.